It happened without warning. No leaks, no signals, no gradual buildup that usually gives Washington time to prepare responses. Late today, a legal move connected to Donald Trump quietly entered the system, and within minutes, the reaction inside the Capitol shifted from routine to urgent. This was not the kind of filing that appears on schedule. It was the kind that disrupts schedules, and Washington was not ready for it. Inside federal buildings, the initial moments were marked by confusion. Not public confusion, but internal. Staffers who monitor court activity flagged the submission. Almost immediately, phones began ringing. Meetings already in progress were paused. Calendars that had looked settled just hours earlier suddenly needed revision. This is how genuine surprise registers inside the system. Not through dramatic statements, but through rapid recalibration. What made this move so unexpected was the timing. Washington operates on rhythm, predictable cycles, known deadlines. Even in high-profile cases, there is usually some advance notice, some whisper of what might come next. This time, there was nothing. The move landed cold, without context, forcing everyone to play catch-up. At the same moment, legal observers began analyzing the filing immediately. But even they acknowledged something important in the first hour. The full scope wasn't yet clear. What was clear was that the court now had to respond, not with a ruling, but with acknowledgement. Once a filing meets procedural requirements, the court cannot ignore it. It must decide how to handle it, even if that decision is simply to set a timeline for response. That obligation alone changes the pace of the case. Opposing legal teams found themselves in an unfamiliar position. Normally, there is time to prepare, time to coordinate, time to shape messaging before the public learns details. This time, the clock started before preparation began. Drafts were reopened, arguments were reconsidered, strategy sessions that were meant to happen over days were compressed into hours. This is what being caught off guard looks like in the legal world. Not panic. Pressure. Inside courthouse chambers. The reaction was measured but intense. Judges do not react emotionally, but they do react structurally. When a filing arrives without warning, the first question is always about scope. Does this affect anything already in motion? Does it touch deadlines already set? Does it introduce issues that must be addressed before other steps can proceed? If the answer to any of those questions is unclear, caution becomes the only responsible response, and caution slows everything down. What makes this moment especially significant is that the surprise itself may be part of the strategy. Experienced legal teams know that timing can be as powerful as argument. A move that arrives unexpectedly forces opponents into reactive postures. It compresses their decision windows. It limits their ability to coordinate, even if the filing does not win immediately. It may win by disrupting the other side's rhythm. That disruption is already visible. Washington insiders report that conversations behind closed doors have shifted from what happens next to how fast can we respond without making mistakes. That shift in language is telling. When the question becomes about speed versus accuracy, it means pressure is working. It means the unexpected move has already achieved part of its objective, regardless of what the court ultimately decides. Media coverage is beginning to catch up, but the story is still developing. Initial reports focused on the fact that something happened. Now, attention is turning to what it means. Analysts are parsing language, comparing it to past filings, and searching for clues about intent. But even the most experienced commentators admit at this stage, certainty is limited because the court has not yet responded. And until it does, speculation fills the space that clarity will eventually occupy. What happens next will depend on how the judge chooses to proceed. Some courts respond quickly with procedural orders. Others take time, allowing the filing to settle before engaging. Both approaches carry risks. Moving too fast can create vulnerabilities. Moving too slow can allow uncertainty to compound. Judges are acutely aware of this balance. And right now, that balance is being weighed carefully for Trump's legal team. The silence from the court is not necessarily a setback. In some cases, delay is benshin josher, a form of validation. It suggests the issues raised cannot be dismissed instantly. It suggests the court is taking the filing seriously enough to consider its implications before responding. That consideration takes time, and time, in this context, is attention. As the hours pass, one thing is becoming clear to everyone watching closely. This move was not designed to blend in. It was designed to interrupt, to surprise, to force Washington out of its predictable rhythm and into a posture it did not choose. And whether the court rules quickly or slowly, that objective has already been met. Because Washington is no longer operating on its own timeline, it is responding to someone else's. As the initial shock begins to settle, a more complex reality is emerging inside the legal system. Surprise filings do not just affect schedules. They affect psychologists, judges, clerks, and opposing counsel. All operate on assumptions. When those assumptions are disrupted, even slightly, it changes how everyone approaches the next step. And that change is already underway inside the courthouse. The first procedural question is always the same. Does this filing require immediate action? If the answer is yes, the court must prioritize it over other matters. If the answer is unclear, the court must take time to determine what kind of response is appropriate. Either way, momentum shifts. Other cases slow down, internal resources are redirected, attention narrows. This is what being caught off guard means inside the system. Not chaos, but realignment. Opposing legal teams are now operating under conditions they did not choose. Instead of executing their own strategy, they are responding to someone else's. That distinction matters more than most people realize. When you control the pace, you control the pressure. When you are reacting, you are always one step behind. And in high-stakes litigation, one step can be the difference between winning and losing. This is the position Washington now finds itself in. Legal analysts are beginning to identify patterns in the filing that were not obvious in the first hour. The language is precise. The structure is intentional. The timing appears carefully chosen. These details suggest the move was not rushed. but prepared well in advance and held until the right moment. That level of planning changes how seriously the court must take it. Judges are trained to distinguish between reactive motions and strategic ones. This one falls into the second category, and that classification carries weight. Another factor now influencing the court is the record. Every decision made from this point forward will be reviewed later, not just by higher courts, but by historians, commentators, and future litigants. Judges know this. They know that how they handle surprise matters as much as what they ultimately decide. A rushed response can be criticized. A delayed response can be questioned. The goal is to appear measured regardless of external pressure. That goal shapes every action behind closed doors. Discussions are becoming more specific. Clerks are drafting summaries that highlight potential conflicts with existing orders. Judges are reviewing prior rulings to ensure consistency. Every angle is being examined before any public step is taken. This is the hidden work of the judiciary. Work that happens without cameras, without headlines, and without public acknowledgement. But work that determines everything for Trump's legal team. The waiting game continues. There has been no rush to amplify the filing through media appearances. No urgent statements framing the narrative, just silence. Legal experts interpret this restraint as confidence. Teams that need public pressure to win often speak early. Teams that believe their arguments will stand on their own let the document speak first. In this case, the document is speaking loudly enough. Opposing counsel now faces a dilemma that has no perfect solution. Respond too quickly, and they risk mistakes. Respond too slowly, and they risk appearing unprepared. Strike the wrong tone, and they may alienate the court. This is the kind of pressure that filings like this are designed to create, not to win immediately, but to force the other side into uncomfortable choices. And those choices are now being made. What makes this moment especially tense is the uncertainty about what comes next. Will the court issue a narrow procedural order? Will it request additional briefing? Will it schedule a hearing to address the issues raised? Each possibility carries different implications. Each would shift the case in a different direction. And until the court acts, no one knows which path will be chosen. Media coverage continues to build, but it remains reactive rather than predictive. Commentators are describing what happened, not what will happen. That distinction reflects the reality of the moment. Even the most informed observers are waiting for signals from the bench. Those signals have not yet arrived, but they will. When they do, they may not look dramatic. A short order, a revised deadline, a request for clarification. These actions do not make headlines immediately, but they define the battlefield. They tell both sides what the court is willing to consider and what it is not. That information is gold in litigation. Right now. Both sides are waiting for it. As the hours turn into days. One reality is becoming impossible to ignore. This filing has already achieved something significant. It has forced Washington to pause. It has disrupted assumptions. It has introduced uncertainty. at a moment when certainty was assumed, whether the court rules quickly or slowly, whether the motion succeeds or fails, that disruption will shape everything that follows. Because in the legal world, control is not just about winning, it is about who sets the pace. And right now, the pace is being set by someone Washington did not expect as the legal process continues to absorb the impact of this unexpected filing. Attention is now turning to what comes next, not because anyone has inside information, but because courts cannot remain silent forever. At some point, the judge must act. And when that moment comes, the response will reveal more than any speculation ever could. What makes this phase so critical is that the court's first move will set the tone for everything that follows. A narrow procedural order sends one signal. A request for briefing sends another. A scheduling adjustment sends a third. Each choice communicates something about how seriously the court views the issues raised, and each choice limits what can happen next. This is where experience matters most. Judges who have handled high cases before understand that early decisions create lasting impressions, not just on the parties involved, but on higher courts that may review the case later. Every word must be chosen carefully. Every step must be defensible. That awareness slows the process, but it also strengthens it. Opposing legal teams are now preparing for multiple scenarios. Some are drafting responses to questions that haven't been asked yet. Others are reviewing the record for vulnerabilities they may have missed. Still, others are quietly reassessing whether their original strategy still makes sense. This is what pressure looks like beneath the surface. Not panic, but preparation under uncertainty. For Trump's legal team, the waiting game remains deliberate. There has been no rush to claim victory, no attempt to spin the narrative before the court responds. That restraint is being noticed. In Washington, confidence is often measured by silence. When teams feel secure in their position, they let the process unfold. When they feel vulnerable, they try to shape perception. So far, the signal from this side has been clear. Patience inside the courthouse. The judges weighing options that balance competing interests, fairness to both parties, efficiency of the process, protection of the record, consistency with prior rulings. Each of these interests matters. None can be ignored without creating risk. The challenge is finding a path that respects all of them while still moving the case forward. That path exists, but it takes time to identify. Legal scholars watching from outside note that this moment is familiar in structure, even if unique in context. High-profile cases often reach inflection points where process becomes as important as substance, where how the court manages uncertainty determines how the case is remembered. This is one of those moments, not because of the filing itself, but because of what it forces the court to confront. As days pass without a visible response, anticipation will continue to build. Media coverage will sharpen. Commentary will become more confident, even without new information. Public attention will drift toward other stories, then snap back when the court finally acts. This cycle is predictable, but that doesn't make it less impactful. Because when attention returns, it returns with accumulated weight. The next visible move may be quiet. A one-page order, a brief scheduling notice, a request for supplemental briefing. These actions don't generate headlines on their own, but they generate clarity. And clarity is what both sides have been waiting for. Once the court signals its direction, the case will enter a new phase. 1. Defined not by surprise, but by response. What cannot be undone is the disruption already caused. Washington was caught off guard. Schedules were disrupted. Assumptions were challenged. Even if the court ultimately denies the filing entirely, that disruption will have lasting effects. Trust in predictability will be slightly diminished. Caution will increase. Future moves will be viewed through a different lens. This is how momentum shifts without winning, not through victory, but through forcing others to adjust. For viewers watching from outside, the lesson is simple but important. In high-stakes legal battles, the moments that matter most are often the ones that happen quietly. Not verdicts, not dramatic rulings, but the moments when the court decides how it will manage uncertainty. Those moments are unfolding right now. And when the next chapter of this case is written, it will trace back to this filing, this surprise, and this period of quiet recalibration. Because in the legal world, control is not about speed, it is about direction. And direction is being set right now.